This incident has completely turned my life upside down. I couldn't work several weeks after the incident because I have a customer-facing position and my face was black and blue and yellow. I now can't leave the house without a firearm on my hip for not only fear of him, but fear of people that he associates with. My 14-year-old daughter, who luckily was not there when this happened, but she didn't want to come back to my house because she was afraid. I've installed security cameras around my house. I don't go anywhere. I don't do anything. I don't talk to anybody because I can't trust anybody now.
The defendant pled guilty to a lesser included offense of count 1 being domestic violence, a felony of the 4th degree, and count 2 disrupting public services, a felony of the 4th degree. In case 26 CR 348, the defendant pled guilty to attempted failure to notify sheriff of residence or temporary domicile, a felony of the 5th degree, and we are here today for sentencing on both cases.
Thank you, Mr. Johnson.
Thank you, Your Honor. May I be heard?
Yep.
Your Honor, so before addressing mitigation, I want to raise a threshold issue, a legal issue.
Right.
The domestic violence charge and the disruption of public services charge, it both arose from the same incident. Which my understanding of this case is that it did arise from the same incident and the same exact conduct. May be allied, that they're allied offenses of offenses of similar import under ORC 294125. Your Honor, if the court finds that in this case, if that court finds that to be the truth in this case, those counts must merge, and the state must elect which to proceed on for sentencing.
All right, Ms. Gold, is your position as to whether these are allied offenses?
Your Honor, it is the state's position that the domestic violence and disrupting public services are not allied offenses of similar import. Both of these offenses include different conduct. The harm from the domestic violence is the defendant's act of striking the victim. The conduct in the disrupting public services is the defendant's act of taking the victim's phone and smashing it to the ground so that she could not contact 911. The harm from each of these is a different harm. The animus is different. The purpose is different. These are very distinct acts and thus do not merge.
All right, the facts in this case indicate these are not allied offenses of similar import, so I'm not going to merge them. Go ahead, Mr. Johnson.
Thank you, Your Honor.
Yes, stand up, please.
So, Your Honor, we fully understand that the offenses that are placed before you today, they're serious. Mr. Bettinger accepts full responsibility for that, and that's why we're here. He's entered a guilty plea, Your Honor. He's not intending to hold the state to his burden, and he stood up and he acknowledged what he did. Since the incident, he was ordered to have no contact with the victim, and he has had no interest. He has complied fully with the court's order, Your Honor. He has no interest in re-engaging with the victim. He has made that clear through his conduct during the pendency of this case. He's already been in custody since January 6 of 2026. My count makes that 114 days to this point, Your Honor, where he has sat in Lake County Jail for this entire case. From my perspective, Your Honor, he's already served real time, and he's done so without incident. What Mr. Bettinger is asking the court for today is an opportunity to address the root issues, that he is actively seeking wraparound services upon his release. That includes mental health services, Your Honor. That includes substance abuse services, Your Honor. That includes alcohol counseling, Your Honor. And I don't think anyone in this courtroom would disagree that alcohol is one of the main issues that causes us to be before the court today. And I fully understand that alcohol is not the only issue, and that this is an offense of violence. But we have to understand that alcohol and offenses of violence go hand in hand. That is completely true. It's my perspective that Mr. Bettinger is not is not a violent individual without that type of substance. Without mind-altering substances such as alcohol, Your Honor, it's my understanding that he's not a violent individual. He's not someone out on the streets knocking people out and just slapping people around on just a regular day occurrence, Your Honor. We have to take into account the fact that alcohol, that Mr. Bettinger readily admits that he was drinking on that day. the victim in this case will readily admit that he was drinking on that day. Mr. Bettinger will readily admit that he has a problem with drinking alcohol. He's even stated that when I drink, it gets excessive. So, Your Honor, I think that that is a major component of this case that cannot be swept under the rug here. We have to address the alcohol issue head on if we're going to address the issue of the violence. So, Your Honor, given all that, he has a plan for his release. He wants to get housing that he can have, that he can readily allow the sheriff, or that he can readily communicate with the sheriff about in terms of addressing, in terms of updating his address and verifying things. He wants to get full-time employment, which is one of the conditions that would be recommended by probation in this case. He wants to be able to get counseling for his alcohol problem because he's not going to get that at the level at which he needs it in prison. So, Your Honor, I fully understand that in this case, it seems like the right thing to do would be to imprison him, but from my perspective, that's only kicking the can down the road, and it's not really addressing the head-on issue that brings him before him, that brings him before you.
Well, but hasn't he kicked the can down the road? I mean, it's up to him to get the treatment. It's not up to somebody else to do it for him.
Well, Your Honor, that's fair.
Since he's been out of prison, you know, he's been charged with aggravated menacing with this GSI or this SI. He's been charged with some disorderlies, and I would imagine aggravated disorderly. I would imagine most, if not all of them, are related to alcohol. So why hasn't he taken upon himself to do anything about it?
Well, Your Honor, to be fair, he was still using. I mean, he's been out from the streets for 114 days. I'm not sure prior to this point, his last incarceration date that would have been, to that point or longer, would have been at least 20 years ago. So, Your Honor, we're looking at a different person. You're talking about somebody who's now had that time, opportunity to actually really appreciate his conduct and what's caused him to be before you today. I would argue to you, Your Honor, that those misdemeanor cases that you were listing in terms of aggravated disorderly conducts, they don't rise to that level, if we're being realistic. This felony case, however, Your Honor, that has caused him to lose everything, is put things into perspective. And I believe that having had that opportunity to put things into perspective, to sit down, to take a break, and to really reflect on what is the issue that's causing him to have interactions with law enforcement, interactions with this court system, Your Honor, I believe that now he's trying to take those steps to help himself. And I don't believe that going to prison will allow him to do so, Your Honor. It will only prolong the situation that caused him to be before you today. So, Your Honor, I just ask that, considering the fact that he has fully accepted his responsibility, he has had voluntary compliance with the no contact order, he's already served a substantial amount of time, and he has demonstrated commitment to getting help in this matter, Your Honor. I would ask that the court take all of that into consideration, and we would ask that the court impose concurrent sentencing, and we would ask that the court imposes community control in this matter. Thank you.
Thank you. Mr. Bettinger, what do you want to tell me before I impose sentence?
Your Honor, I messed up. I screwed up, and I take responsibility, and I want to get help for that. I also underlying problem with anger, and when there's alcohol involved, it can bring out the anger. And I do want to speak to someone about my anger, if it's anger management or a counselor or whoever that may be, along as well with an alcohol counselor possibly. In the past, you know, the reason why I didn't take the steps is because, yes, maybe I was still using, but I have had times to where I was not. I have a good career. I'm an artist. I have a lot of outlets that I can use besides using, and I just want a chance. Your Honor, if you can give me a chance so I can fix myself and prove to you and prove to myself and prove to the ones that I have hurt that I know that I can do this, because I know that I can, and I am confident and I'm positive that I can do this.
Well, why didn't you do this after you got out of prison after 7 years?
At that time I didn't. I got out and I wasn't using at that point. And things, I guess, just led me to start using again. And I really don't know why. I don't know why, Your Honor. And I understand that I have messed up since then because of that. And I'm old enough now, and I have a lot to lose. And I don't want to lose any more than I have already lost, and I want to save that. And I just want that chance to try to save that.
Okay, well, you've just talked about things, and Mr. Johnson talked about things that were all within your control the entire time after you got out of prison, all within your control. And you didn't do anything to control them, which led to this. Okay, so what I've heard you talk about was about what you want to do, what you have to do, what you have to lose, what you've already lost. So where does the victim fit into this whole thing?
The victim fits in to the hurt that I caused her. And I don't want to hurt anyone else. The victim falls into, from me using, the victim falls into my mistakes. The victim falls into me not being smart, me not thinking.
I mean, you call them mistakes. I don't consider them mistakes. I consider them actions that you voluntarily undertook. Okay? When did it dawn on you that you have a severe alcohol and potentially drug problem? When did that dawn on you?
Well, I've gotten some DUIs, and after I had gotten them, some time ago, I started to think maybe that I did, and the way my mind was working, I wasn't sure really what to do to take it upon myself.
You've been on probation before, right?
I have, yes.
Okay.
And I've done everything to make it off, abide by all the rules.
So what have you done through probation programming to address your problems?
I've done drug and alcohol assessment.
And what was the result of the assessment? What did they tell you?
They said that they thought that I didn't have a problem, but then I did. I told them that I did.
Your Honor, can we clarify? Are you speaking about this most recent matter, or are you talking about another?
No, I'm talking about any time in the last 20 plus years, 25 years, 30 years.
So the question is, was it ever addressed when you were on probation before?
It wasn't fully addressed.
Well, then say that.
It wasn't. I never got the help that I needed then from probation.
Well, why? Who's that on? Who's that on? You said you never got the help you needed from probation. Who's that on?
That would be on myself.
Right. Okay.
And why didn't you?
So all this goes on for the better part of 30 years, and nothing's been done about it, and it results in this. What you did to her that night.
I wasn't really sure, I guess, what the proper steps to take before this had happened, so this wouldn't happen to her. And I now want to take the proper steps from the help so it doesn't happen again.
You should take the proper steps.
And I would like to. I would like the chance so I can take the proper steps so it doesn't ever happen again, because I do not want it to happen again, so no one else gets hurt. And I didn't want her to get hurt.
Well, then you shouldn't have whacked her in the face if you didn't want her to get hurt. Right?
Yes. Yes, I was using at that time when it happened, and I wasn't clearly thinking correctly. And you know, at this point, it's not, none of that is worth it. None of that is worth just having a drink. None of that is worth any of this.
I would imagine that back in April of '07 that the felonious assault had something to do with you being drunk or high, right?
Yes, Your Honor.
Okay. Now, why is it that this is now the second time you haven't registered as a sex offender?
Whenever I had lost my place, I was with the victim. I was staying there. It wasn't a permanent address because I had planned on getting another place.
Well, how long had you lived there?
I'm not sure if it was 5 months, 6 months possibly.
And you knew you had to report, right?
Well, I thought that if it was a real address that was mine, I wasn't really sure how that worked.
So what happened when it happened in Ashtabula also?
That was for my vehicle, because my vehicle wasn't entered in there, and I thought that they had just wanted my residency, and that was when I was staying with my father, and I didn't have my vehicle registered.
Well, your obligation was to have that registered, right? Your obligation is when you move to another domicile, whether it's temporary or permanent, that you have the obligation to register, right?
Yes, Your Honor. Well, I thought that if it was permanent, I didn't know if it was temporary.
Well, see, but this is, once again, this is on you. Okay? This is your responsibility. You were read the form when you were sentenced on that thing, and you were told exactly what you had to do, and you signed a form acknowledging exactly what you had to do. You didn't do it in Ashtabula. You would think that if you didn't know the rules when you got tagged with it in Ashtabula, you'd have learned the rules pretty quick, so you didn't get tagged with it again. But you didn't do that because you didn't see it as being very important.
That's
why you didn't do it, right?
Well, I did see it as important. I didn't know if it could, because it wasn't a permanent residence.
Okay, but that goes back to what I just said. If you got in trouble for it in Ashtabula, you should have sat down and looked at the rules or talked to the deputy, found out exactly what the rules were so it didn't happen again. Anything else you want to say?
Yes, I would like to have a chance to fix myself and correct myself the proper way with counseling and treat. And I want to, I'm taking full acknowledgement of, how the victim feels, and I would like to talk to somebody about my situations, and also in a way apologize to the victim. I know I can't speak to her, but whatever she went through and how she went through it, the sadness that she went through, the hurt, I didn't want that to happen. I didn't mean for that to happen. And since I've been in here, I have hurt over that also, of how she's felt from my actions.
All right, Ms. Gold.
Thank you, Your Honor. It's my understanding that the victim in this case would like to speak. Is now the appropriate time for her to do so?
Go ahead.
Good afternoon, Your Honor. My name is Heather Conyers. I was the victim in this particular incident. I know you have my victim impact statement in front of you. I just wanted to hit on a couple of points that this incident has completely turned my life upside down. I couldn't work several weeks after the incident because I have a customer-facing position and my face was black and blue and yellow. I didn't want to get questions from my clients and customers about what happened to your face. I now can't leave the house without a firearm on my hip for not only fear of him, but fear of people that he associates with retaliating against me for standing up and saying, no, this isn't right, this shouldn't have happened to me. My 14-year-old daughter, who luckily was not there when this happened, but she didn't want to come back to my house because she was afraid. She didn't know if he was going to get out and come back and hurt us more. I've installed security cameras around my house. I don't go anywhere. I don't do anything. I don't talk to anybody because I can't trust anybody now because of what Mr. Bettinger did to me. That's all I really wanted to say. Other than that, I will just rely on the impact statement I wrote.
All right, thank you. Ms. Gold?
Thank you.
Thank you, Your Honor. The defendant has a history of violence, as evidenced by both this case and by his criminal history, as Your Honor saw in the pre-sentence report. And this begins back in 2000, when the defendant was convicted of child endangerment. Your Honor, the case in 2000, in that case, the victim was the defendant's 5-week-old child. And in the judgment entry and the sentencing of that case, the Geauga court noted that the defendant has shown a repeated pattern of substance abuse. And there's been nothing to prevent the defendant, between his release for the child endangering case and the incident in this case, from seeking treatment on his own. And this is not to say that the defendant should not now seek help, but the defendant seeks to use obtaining treatment as an avenue to evade punishment and accountability for his actions. In addition to the child endangering case, the defendant has a misdemeanor domestic violence case in the Painesville Municipal Court, another child endangering case involving injuries to the same 5-week-old infant, felonious assault in 2007, and then the domestic violence case we're here for today, where the defendant struck the victim in the face, and after doing so, smashed her phone so that she would not have the ability to call 911. And after the defendant had a sexual imposition conviction in Twinsburg in 2021, attempted failure to register, and then again attempted to fail to register in this case. The defendant has shown that he is not changing his violent ways over the last 25 years. For the reasons that the victim has explained when she spoke, and as you've read in her victim impact statement, this incident has impacted her. It's impacted her feeling of safety in her own home. It's impacted her ability to go to her job and to live her day-to-day life. The state believes that a prison sentence is appropriate in this case. Thank you.
And on 26053, on count 1, I'm going to sentence you to 17 months in prison. On count 2, 12 months. Those two counts will run concurrent to one another. You get credit for 115 days. On 26348, I'm going to sentence you to 11 months.
Under Ohio law, the court proceeded to sentencing following the defendant's guilty pleas to domestic violence and disrupting public services, both 4th-degree felonies, and attempted failure to notify the sheriff of a residence change, a 5th-degree felony. The court declined merger under Ohio Revised Code Section 294.1.25, finding the offenses involve separate conduct and distinct harm. In applying the purposes and principles of felony sentencing under Ohio Revised Code Sections 2929.11 and 2929.12, the court found significant recidivism factors. The defendant's criminal history spans over 3 decades and includes prior violent offenses, repeated probation violations, and failure to comply with sex offender registration requirements. The court determined that the defendant is not amenable to community control sanctions and that a prison term is necessary to protect the public and punish the offender. Consecutive sentences were imposed pursuant to Ohio Revised Code Section 2929.14, based on findings that such terms are necessary, not disproportionate, and supported by the defendant's history of criminal conduct. The aggregate sentence imposed was approximately 28 months of imprisonment. The defendant was also advised of potential post-release control supervision upon completion of the custodial term.